I'm going to talk about some estate planning basics and questions that I commonly get asked as an estate planning attorney. My name is Shawn Garner. I'm with Deason Garner and Hanson. And one of the questions is about naming beneficiaries on accounts or vehicles and even real estate. So let's get into it. I want to do it by way of example. I want to introduce you to Bill and Mary Jones. This is a family that we're going to use to take through a scenario of naming beneficiaries on every single asset that they have. So they're retired, they've got two kids. John, he's kind of a deadbeat. Susan, who they rely on heavily for anything, they trust her with their lives. So they hold everything jointly, and their plan is to name John and Susan as joint beneficiaries on their accounts, on their vehicles, and on their home. Most people, that is the three types of assets that are going to be used to have beneficiary designations. You could do it on bank accounts, you could do it on financial investment accounts, IRAs, typical. Vehicles is somewhat a newer thing, and not everybody's familiar with that. And real estate is the same thing. It's a little bit older, but there's a specific way in how to do it, and we'll go over that. The benefits of doing this is it's easy. It's easy once it's done correctly for the asset to transfer. You don't have to go through probate, and so it's a very informal process. Let's get right into how you would do it with a vehicle, because most people know how to do it with bank accounts and financial institutions. One thing I will note about bank accounts is if you go to add somebody on the bank account thinking you're naming them as either a power of attorney or as a beneficiary, you might actually get somebody named as a joint owner on the account. The result would be, yes, they would inherit the account when you pass away, but you also would actually combine their liabilities with that account, and they have control over that account immediately, which might not have been your intention. Okay, getting on to naming an individual for a vehicle. This form is what we use in Arizona. It's simple. You put down the VIN number, year, make, and title, which is on the actual paper title of your vehicle. Name the beneficiaries down below, and include whether you want them to own it jointly. That would be and, so you could do John and Susan, or if you want them to own it with both independent control, that'd be John or Susan. And that little asterisk means there's more description down on this form, and we'll include the form in a link down below. Now, with a house, you can do that through a beneficiary deed. Beneficiary deeds, they are only impacted or they become effective upon death. So you can record them and not worry about a bank being concerned that you've transferred the property. You can also revoke them, so they're not permanent. If John mouths off at dinner, you can revoke him from the beneficiary deed that you did and create a new beneficiary deed with Susan. They do have to be recorded before you die, so that is an important point. If they're not recorded, even if you wrote them out, signed them, had them notarized, handed them over to Bill or to John and Susan, they would not be effective if Bill and Mary did not have them recorded before they died. So we call this budget planning. And it's a good way to get things done and designated to individuals that you want to have a specific asset, but it's not a substitute for a comprehensive estate plan. If all you wanted to learn about was those types of transfers, naming a beneficiary, then you could stop the video now. But I'd recommend you give us a call and we could discuss your estate plan and your objectives. I'm going to talk about an alternative to that, and that is a living trust, what we refer to as a comprehensive estate plan, because a small error in beneficiary designations on a house or a car or a bank account can result in big problems. They're not flexible, so if you wanted to have special instructions, it's not going to be feasible for that. And there's no scenario for incapacity. So let's just go through Bill and Mary's situation and see how it applies to her. When Bill passes away, since they own the accounts jointly, Mary will own everything. But if she has dementia, then we're going to need somebody to manage those accounts for her. If they did everything properly and named the beneficiaries, well, they still don't have an actual person that has control over the accounts because the beneficiary designation isn't effective until both Bill and Mary pass away. So when Mary needs that day-to-day administration of her assets and healthcare decisions made, there is no plan for that with just beneficiary designations. An alternative way is to use a power of attorney in combination with a living trust and additional estate planning documents, which we call a comprehensive estate plan. They can put all of their assets, rather than naming a beneficiary, they could put those assets in a living trust. That allows them, Bill and Mary, to control their house just the same way they would before. There's no additional fees or taxes to do that. And then if they went through that scenario where Bill passes away, Mary, she will still control the trust assets without any additional paperwork. And if she becomes incapacitated, then Susan, who she's named as the trustee of the trust after her, now has control over all the assets. And with the power of attorney in place, she can make legal decisions. And then an additional healthcare power of attorney, obviously, she'll be able to make those healthcare and living decisions as well. So when Mary passes away with a comprehensive estate plan, Susan, she will be able to distribute the assets without any probate, because a probate is only the process of having the court in control of the assets of a living person. Here, the trust is living still, and it has title to all the assets. Bill and Mary don't have any assets in their name. Susan transfers them to herself and her brother as the beneficiaries, and that accomplishes Bill and Mary's estate plan. So if you want to talk more about this, give us a call for a free consultation. We don't charge to help organize and outline an estate plan scenario for you personally. You can visit us at yuma.law or give us a call. You can click here on this link and you can schedule an appointment online right now or just give us a phone call.